So we are picking up the Companies Amendment Bill 2020 along with the draft CSR rules, and that's our topic for discussion today. This is going to be a small presentation. As I mentioned, this is experimental as we're trying to see how this whole thing works. Now, in terms of understanding of the Companies Amendment Bill, let me first start with a small disclaimer that the whole objective of this presentation is to initiate academic discussion around the topic. This is not a professional presentation, it's not a professional advice, and therefore no part of this presentation is intended to be relied upon by anyone for any professional work. With this in place, let's proceed further, and we're talking about the Companies Amendment Bill 2020, which was placed before the Parliament, before the Lok Sabha a few days back. And we must also remember that the inspiration for the Companies Amendment Bill 2020 is basically a report of the Company Law Committee, known as the N.J.T. Srinivas Committee, which had given its recommendations around 3 or 4 months back in the month of November 2019. And the major theme of the the Company Law Committee was basically simplification and decriminalization of Companies Act to further what is commonly referred to as the ease of doing business. So the entire perspective of this amendment bill is to assure the ease of doing business. Most of the proposals are towards that. In respect of CSR, which is a sort of a topic on which things are getting more and more prescriptive, maybe from ease of doing business, we probably might be deviating a bit somewhere else, but that's something that we need to discuss as we proceed further. Let's first focus on the Companies Amendment Bill 2020. So in terms of the major theme, that's, as I mentioned, decriminalization. What exactly is that? Lots of provisions of Companies Act, as one must already be familiar with, provide for prosecution by way of fine or imprisonment. There are some provisions which talk about fine only, and there are some provisions which say fine or imprisonment. There are some which say fine and imprisonment. Now, wherever the law is providing for a fine, the process of imposition of fine is by way of a prosecution, which is a criminal process. The way it goes is the registrar of companies issues a show cause. The show cause responded to. If the show cause is not successfully dispensed with or disposed of, then the department files a prosecution. The matter goes to magistrate court. The person is indicted by the magistrate. Final conviction happens by the magistrate. And that's, of course, a criminal process. And when it comes to criminality of companies, there's been a long discussion all over the world as to what is the point of putting companies to a criminal prosecution. This is by itself a very elaborate topic. The discussion on the topic dates back to more than a few hundred years. In fact, way back, even during the East India Company regime, we're talking about something like 200 years back, the question of punishing companies came before the House of Lords in the UK at that point of time, and it was mentioned before the House of Lords that companies are artificial entities. They have no brain, no body or no brain, and therefore they do what they want to do. There's no question of punishing companies. That was the original position. Thereafter, as lawmaking developed, the question of punishing companies and inflicting companies with the same punishment as applicable to individuals has gradually been propounded by companies. There's a so-called doctrine of attribution. So if the company does something wrong, the attribution of the offense is on the person running the company, and therefore the directors become liable for the company's offenses. But that's the process of punishing companies. The issue basically is that as directors in companies for corporate law offenses are prosecuted with a fine or imprisonment, the process anyway goes to a court. And for a long time it's been discussed that ultimately the objective is to encourage compliance. The objective is not to as much to punish. And the process of punishment does not result into a major monetary inflow for the government. The total collections by way of fines have not been very substantial. At the same time, the indignation, the kind of embarrassment that the accused goes through is substantial. Ultimately, the accused bears the stamp of an offender under the law, and therefore carries that mark of having been prosecuted for a legal offence for as long as he lives. Now, instead of this criminal prosecution, maybe a pure monetary penalty could be imposed. That's been the theme ever since over the last couple of years. Lots of provisions have already been, lots of provisions have, the prosecution provisions been replaced by penalties. And penalties purely a monetary penalty, and penalties are imposed by the department itself. There's no involvement of judiciary, there's no involvement of magistrate. So penalties are purely monetary and they are handed down by the departmental officers. So in this Companies Amendment Bill 2020, the process of decriminalization, which happened earlier as well, is carried forward. In some cases, penalties or prosecutions have been dropped altogether. In many cases, provisions for fine or imprisonment have been replaced by monetary penalty. Let's not feel happy that paying a penalty is like a jiffy, because the amount of penalties is substantial. And please also appreciate that when it comes to a penalty, it's a purely departmental process. So the question of facing a court and trying to prove yourself innocent, that opportunity may not be available in case of a penal proceeding. Let's move on to the next theme of the Companies Amendment Bill 2020, which is the provisions about CSR. Now, on CSR, as I mentioned earlier, there's been a lot of prescriptive process coming from the lawmakers. Lawmakers have somehow realized that the CSR provisions have not been taken seriously by the corporate sector. Now, if I were to step back and look at what was the original proposition in 2013, when the Companies Act 2013 was framed, the other Minister of Corporate Laws, Sachin Pilot, has gone public to say that the provisions of CSR are comply or explain provision. They are not penal provision. They are not mandatory in nature. They are still throwing a sense of responsibility. If you're responsible, show the responsibility by complying. But if you're somehow not able to comply, just explain the non-compliance. I would also like to state that India stands out in the world as almost a sole exception of a country which has legislated the idea of a corporate social responsibility. Lots and lots of countries have the concept of corporate social responsibility or business responsibility, but responsibility is something which countries have left it open for people to feel responsible about, instead of imposing responsibility as a statutory obligation. India went that way, imposed it as a statutory obligation, as I mentioned, with no kind of monetary no penalty, so to say, until the proposed amendment, which is now proposing to impose a penalty for non-compliance. So it will no longer be a comply or explain provision, either comply or suffer. That's the theme. Now, if you also recall that when the section 135 was amended, the provision talked about a fine or imprisonment for non-compliance with the section. And then the finance minister went public to say that we are moving to a theme of decriminalization, and for CSR as well, instead of a fine or punishment by way of imprisonment, we would replace it with a monetary penalty. So that's how we are. We are now talking about a monetary penalty. Plus, please understand what is the extent of monetary penalty we're talking about. Here we're talking about a penalty equal to twice the amount of the failed transfer. Please understand, it's a huge penalty we're talking about. We're talking about twice the amount of the failed transfer. So if the company does not transfer what the company was supposed to transfer, the company then ends up paying double the amount of the failed transfer. Now here at this stage, it can of course at the max stretch to rupees 1 crore. For example, if my targeted amount was rupees 2 crores and I spent only 1 crore, the deficit therefore is 1 crore. Double of that is 2 crores, but maximum penalty can still go up to rupees 1 crore. So I'll be called upon to pay rupees 1 crore as the maximum amount of penalty. It's not just the company which is liable to pay this penalty, the officers who are in default. Now it's always a question as to who is the officer in default. There are elaborate provisions in law as to what is the meaning of the term officer in default. The officers who are responsible for this, which actually might include the members of the CSR committee as well, will also have to pay 1/10 of the failed transfer, going up to rupees 2 lakhs. So that's the amount of penalty we're talking about. Now, before I proceed further, let me first explain what's the concept of failed transfer. Now, there are 2 points that we need to understand here. that as the amendments and the CSR provisions were made, a concept of a targeted transfer, retention of money for what is called ongoing CSR projects, and the obligation to transfer the unspent amount to a national fund. All of these concepts were mooted. In other words, I have a target to spend, I have not been able to spend fully, so I have an unspent amount. The unspent amount may still be retained for what is called an ongoing project. If I'm not able to retain it, in that case I'll be required to transfer it to a so-called national fund. I'm coming back to those provisions separately as I'm separately coming to CSR. As of now, let me explain another very important point, that as there is a question of a shortfall in spending, there's also a question of excess of spending. So if what I have is not a shortfall, I have an excess of spending, in that case we're talking about here excess spent. So what's the meaning of excess spent? Let's say my target was 2 crores, but because I was constructing, say, a school, and the school needed 3 crores, so I actually spent 3 crores. This excess of rupees 1 crore that I've spent in a particular financial year, this can actually be carried forward. This was our view all the time, even before this particular amendment came. Our view is that if the company has spent excess, next year when the company comes to spending less, the company can offer this excess spending of previous year as a justification for not spending in the particular area. But now the law makes it very clear that if you spent more than what your target was, the excess spending can be claimed as a carry forward. Question: for how many years? Now here, as it seemed from the reading of the law, it says year or years, which would mean there is actually no limit on the number of years for which it can be stretched. However, we are expecting that there will be a rule making on this as well. I'm coming separately on the draft CSR rules, which are still draft rules, but I'll come in. There are lots of points about CSR rules that we need to discuss still. Now, coming to the next provision about interim financial statements. As most of you are anyway aware, interim financial statements, that is quarterly or half-yearly financial statements, are currently required in case of listed companies only. Listed companies prepare, equity listed companies prepare quarterly financial statements, debt listed companies prepare half-yearly financial statements. Now, there is a provision in law to require a specified class of companies to prepare interim financial statements, even if these companies are not listed, whether equity listed or debt listed. What those companies will be, we'll need to see. This is something on which the central government will come up with rules. So that's something that we need to see as the rules come. There is one small but significant simplification in terms of filing requirement. A delayed filing of the so-called MGT 14, which is almost ubiquitous. I mean, for a compliance officer, as he opens his mouth, he talks about MGT 14. That's something which is filed every now and then. So this MGT 14, for which the filing fee was as substantive, was a ton of an amount, the late filing penalty has been brought down to rupees 10,000 plus rupees 100 per day of delay, which is a substantial relaxation in the additional fee required. Moving forward, there is a provision for remunerating the independent directors and the non-executive directors in case the company has no profits or the profits in particular year are inadequate. What is the concept of inadequacy of profits or profits not being there? As many of you are aware, in case of public companies, there is a provision of law which says the remuneration, managerial remuneration is limited to the extent of percentage of profits. Overall percentage 11% of profits, managing director 5%, all managing whole-time directors put together 10%, executive directors and managing directors all put together comes to 10%, non-executive directors, if the company does not have EDs, in that case 3%, if the company does not have EDs, 3%, if the company has EDs, in that case 1%. So limits are 1, 3, 5, 10 or 11% of profits. As all the limits are, as you can see, based on profits of the company. What if the company does not have any profits in a particular year? If in a particular year the company has no profits, there's nothing to pay to independent directors or non-executive directors. So the question is, independent directors spend time when they get remunerated only two ways: sitting fees and a commission based on profits. If there are no profits, I get nothing. So what is it that I'm spending time for if I get nothing? And therefore, there's a proposed provision to insert a minimum remuneration clause in Schedule 5, similar to what we have in case of professional directors, so-called minimum remuneration, where profit or no profit, a certain minimum amount can be paid to IDs and NEDs, even in a year of no profit or inadequate. When I say inadequate, inadequacy would mean the targeted or desired amount that we need to pay versus the stipulated percent of profits. For example, if I need to pay 20 lakhs to all my independent directors put together, my profits for a year are, let's say, rupees 2 crores. So 1% of 2 crores comes to 2 lakhs. The amount I intend to pay is 20 lakhs, and therefore that becomes the minimum remuneration. There is a major proposed relaxation to companies going for debt listing. Now let me just explain the issue. Currently, the definition of a listed company refers to a company whose securities are listed. So when I talk about securities being listed, securities could be either equity or debt. And it's quite often so that a private limited company might have offered debentures to, let's say privately, and those debentures have been taken for listing. So if the debentures are taken for listing, the company becomes a listed company. As a listed company, it comes for all the compliances applicable to listed entities, and that is a major disincentive for issuing debentures or getting debentures listed. This is something which has been pointed out several times, that in India, very often companies are deterred from going for bonds because most bonds are actually listed, and listing leads to listing related compliances. So here the provision says the central government may exempt such class of companies having such securities as the government may prescribe, which will not be regarded as listed companies despite having their debentures listed. We are hoping that all debt listed companies will get excluded by virtue of this carve out. There is a proposal for what is called direct listing overseas. So direct listing overseas is a concept which was mooted by SEBI, and it's been there in public domain for some time. That is, companies which propose to take their shares for listing overseas without having equity shares listed in India. Now the statute is proposed to be amended to make this possible, to have direct listing overseas. And as companies go for listing overseas, the rules of sections 89 and 90, 89 pertaining to declaration of beneficial ownership, because most of these global issuances would be in form of, let's say, ADRs, and therefore section 89 might be attractive. So section 89 and section 90 both may be exempted for specific classes of overseas listed securities. The provisions about producer companies, this is a concept which was there in the 56 Act. The idea is to corporatize producer cooperatives. Agricultural farmer cooperatives and producer cooperatives are intended to be corporatized, something which the Agriculture Ministry has time and again been pressurizing the government on. These provisions were there in the 56 Act. Somehow they were dropped in 2013 Act, and those provisions are now making a comeback. Minor provisions about shifting the jurisdiction of criminal prosecution for officers who are charged for wrongful withholding of companies' properties, and that the provisions on timelines for rights issues might also be reduced. That brings us to the Csr Amendment Rules. Now, as I mentioned, there is a substantial proposed change in CSR rules, and the rules are talking about lots of new concepts. Besides talking about so-called unspent CSR money, they're talking about what is an ongoing project, defining what is an ongoing project. The rules are also very interestingly almost forcing the corporatization of the intermediaries, the implementing agencies or the so-called trusts or foundations which are engaged in CSR execution. These entities may necessarily go for corporatization. That's a very important provision, and those entities will also come under some kind of government intervention because these entities require registration with the central government. That's a very, very important change. So I'll talk about that, and also try to talk about what exactly is the meaning of implementation agencies. I'll come to that one after that. Let's first discuss there is a negative list of attributes of CSR activities which will not be regarded as CSR activities. For example, ordinary business activities. If the company is doing something which is a part of business model, that will not be regarded as CSR activity. Spending overseas will not be regarded as CSR activity. Political donations are not regarded as CSR activities. and if the beneficiaries of a CSR spending are the employees of the company, that also is not CSR. However, up to 25% of the beneficiaries may be the employees of the company. Remember, as I mentioned earlier, the rules are getting more and more prescriptive from what is a sense of responsibility and therefore making us feel responsible. The CSR rules are making it more and more law prone, more and more rules prone, and more prescriptive. The moment responsibility becomes a prescription, the idea of trying to wiggle out, the idea of trying to find a way to escape the prescription always becomes predominant. But unfortunately, CSR concept in India has taken a shape where it's getting into a web of rules. So here we have web of rules which is even saying, well, my employees may be beneficiaries, but up to a max of 25%. My professional friends will ask a question, 25% is what? 25% of number, the 25% value. Our view is that the 25% is actually 25% in number. And therefore, one once again might try to play with 25% number, but could be 30% in value, I don't know. Now, I mentioned there's a major change on what is ongoing project. This is exactly coming from section 135/6. And the rules are now seeking to define what is the meaning of an ongoing project. The rules say an ongoing project means a project which is crossing one financial year. A project which crosses one financial, a multi-year project, but going to a max of 3 years. A multi-year project, multi-year meaning multiple financial years. It need not be multiple calendar years, but it's a multiple financial year project, but up to a maximum of 3 years. We're actually seeing quite a few things here. For example, if first of all we're saying that what is an ongoing project has to be a project. It's only a project which could be a multi-year project. A single spend, for example, I am doing, let's say, one-time contribution to, let's say, a charitable, or let's say hospital. I'm making a contribution by way of a one-time contribution to a hospital for whatever the hospital is doing. It's not a project because 1 year, once I've given the money, the project is over. There's no project at all. So a project means a sustained project which is carried over a period of time. That's the very meaning of a project. It's a bunch of activities which is coordinated and which is carried over a stretch of time. That's the meaning of a project. In order to be an ongoing project, the project has to be multi-financial year, which means if I start the project in the month of Feb 2020 and the project goes up to August 2020, it's crossed from one financial year, that's 1920, it goes to 2021. Therefore, the project is a multi-financial year project. And the project cannot be more than 3 years, because the idea basically is that I cannot be taking very, very long-term projects and still claim them to be CSR projects. So the project has to be maximum 3 years. The board of directors will monitor the utilization and the progress of, which is another very important obligation on the board. The board will monitor the utilization, and please also understand that somewhere there's a need for a CFO to give a certificate that the money spent has been actually utilized for the purpose for which the money was contributed. You'll see me talking about that very shortly. Now, the implementation agencies can be only either the company itself could implement, or it would be Section 8 company, or entity established under an Act of Parliament, or international organization. In other words, the day for the trusts or the foundations to carry CSR activities, that is to CSR implementation activities, seem to be ruled out by this. This is a very important change in my view, because most of the major business houses have formed in-house trusts or in-house foundations through which CSR activities are carried out. There are two major proposals in the law. Number one, to say that these entities are corporatized, part one. Number two, they also say that the implementing agency also needs to be registered with the central government. There's a form CSR1 to be filed for registration of the implementing agency. That's another very important concept. So once again, what's the meaning of the word implementing agency? Take an example. I am a company, I am X Limited. I am contributing money to, by way of, let's say, building 10 beds for treatment of, let's say, coronavirus patients, let's say in a particular hospital. I am contributing money for isolation wards to be built into a hospital for a particular 10 patients. The hospital is not a Section 8 company. Therefore, is it required by virtue of these rules that The hospital must also be a Section 8 company? Answer is no. The hospital is the beneficiary of the money. I am the giver of the money. The hospital is the ultimate receiver of the money. The money is going straight from me to the hospital. There is no question of an implementing agency in between. The question of implementation agency comes only when the money is passing through an intermediary. Mostly the intermediary is either pooling or the intermediary is responsible for remitting the money in stages or phases. That's the meaning of the so-called implementation agency. The company is giving the money to the ultimate beneficiary. There's no question of an intermediary agency in between. But if there's an intermediary agency, the implementation agency has to be as per the rules as of now drafted. The intermediary has to be one of these Section 8 company or the company itself or entity established under Act of Parliament. What's the meaning of this? Entity established under Act of Parliament. Some people could probably say, well, I have a trust. The trust is registered under Trust Act. The trust is not established under the Act of Parliament. Established under Act of Parliament would mostly mean statutory bodies. Merely because I register LLP under the LLP Act, I cannot say the LLP is established under an Act of Parliament. Act of Parliament meaning the Act of Parliament is relating to the establishment of the entity. So that's unfortunately my views are that it's only mostly it would be Section 8 company which would be eligible for acting as intermediaries. Of course, there is a grandfathering provision here that whatever projects you already initiated before the implementation of the rules, you can still continue, but henceforth the money will have to be done only through the Section 8 companies. Existing programs are therefore grandfathered. That's a very important part. Otherwise, all this money sitting with the foundations of different business groups will be under some tremendous difficulty. I was talking about utilization certificate. The CFO or the the person responsible for financial management has to give a utilization certificate. The CSR committee has to also formulate an annual action plan. Surprisingly, most CSR committees meet only once in a year and they just don't bother about what's happening on CSR. So CSR committees will have to be a little more active and responsible. Impact assessment, we do the spend. What is the impact of the spending? We did a spending with a particular social objective. Did we meet our objective? So in all those cases where the CSR spend is exceeding rupees 5 crores in the 3 immediately preceding 5 years, I'll mandatorily have to do an impact assessment. Typically, impact assessments are done by what is called social audit or mostly by external agencies. But this is something that we leave it for the CSR committee to decide whether they'll do it themselves or through an impact assessment external body is up to them. If the company is doing an impact assessment or required to do impact assessment, in that case the admin overheads can reach up to 10%. Any CSR or creation of an asset arising from CSR activity will be plowed back or transferred to unspent CSR fund. That would mean if there are assets that arise out of CSR. For example, let's say I decide to build a school as a part of my CSR spend. If the school comes up, the school has to be held by Section 8 company or it has to be anyway public property. It cannot be my property because the idea basically is not to create assets out of CSR spend. Unspent CSR funds, meaning to the extent I have not retained the CSR money for what is called ongoing project. Remember we discussed about ongoing project. To the extent I have not retained the money for ongoing project, the money has to go to a national unspent CSR fund, which is almost like a government fund and will go to the government. Additional disclosures on the website of the company and an annual CSR report. So in short, CSR is getting more and more prescriptive, more and more rule prone. Which is, as I mentioned, that's almost like an exception in the global scenario, but that's how it is. And well, this is our short discussion on the Companies Amendment Bill 2020. Look forward to more of these web-based virtual meetings or webinars with professionals. Look forward to interacting more with you. And I think if this particular presentation is a success, in that case, we intend to do a live webinar as well, where we intend to interact with you. All of you. Thank you very much for being here. Thanks.